what's the worst that can happen with conflicts? The consequences of conflicts of interest, attorney discipline. You can get sanctions, grievances, be reprimanded, even up to being disbarred. Proper client information should include the roles and duties of the fiduciary. Tell the client what the trustee is going to be doing. Put it in writing if they're naming you. Even if it's a separate document, it doesn't necessarily have to be the will. Last but not least, since we're coming up on time here, a lawyer's duty of confidentiality continues after the death of the client.
My name is Nina, and I'll be the moderator for this webinar. I wanted to start out by giving a bit of background on our speaker, Leah Del Percio. Leah Del Percio is the president, CEO, and co-founder of Trustate, one of the world's fastest-growing estate administration platforms. Since Trustate's founding in 2020, Ms. Del Percio has been involved in all aspects of the firm's development and growth. Trustate provides B2B tools to various stakeholders through the estate administration process, including law firms, wealth managers, banks, and accountants, amongst others. Today, the firm is an industry leader in the legal tech space and is regularly featured as one of the top startups to watch. Prior to founding Trustate, Ms. Del Percio was senior trust and estate attorney at DLA Piper, where she focused on helping individuals, families, and institutions with crisis and succession planning, wealth preservation, asset protection, and complex tax strategies. She has been named to Super Lawyer's Rising Stars list on multiple occasions and featured in various publications, including national features in both Law.com and Business Insider. Ms. Del Percio holds a BA from the University of Miami, a JD from Benjamin Cardozo School of Law, and an LLM in taxation from Georgetown University Law Center. She is licensed in Maryland, New York, and New Jersey. The webinar presentation you're about to watch will be approximately 1 hour, and then Leah will be joining us for a Q&A session. So if you have any questions that come up during the webinar, please feel free to submit them through that Q&A button at the control panel at the bottom of your screen. And without further ado, here is Leah Del Percio to discuss navigating and mitigating ethical conflicts in estate administration and planning.
Good afternoon. I'm Leah Del Percio, and I am here today to talk to you about navigating and mitigating ethical conflicts in estate administration and planning. This presentation will be primarily targeted towards those of you who are in a trust and estates practice. Most of my examples will go through this, or if you're working to advise clients of family businesses, really things related to that. So if that makes up, a small part of your practice, a large part of your practice, this would definitely be a course for you. Being in trust and estates, as well as working with family business owners, has its own set of problems, challenges, as well as rewards. That certainly is the case on the challenges side. When it comes to conflicts, it's kind of dealt with differently in a different landscape than other areas of law. So just wanted to throw that out there at the outset. You may also be wondering, why is this person here talking to me? Who is she, and why is she talking to me about estate conflicts? So again, my name is Leah Del Percio. I am the founder and CEO of a company called Trustate. We're an estate management and operations platform that works on estate administrations, trust administrations, estate planning operations, as well as guardianship issues for trust and estates lawyers, trust companies, fiduciary services arms of institutions. You kind of name it in the trust and estate space, and our software assists with it. So kind of a fast rising thing. Because of that, we've settled thousands of estates at my time at Trustate, not to mention the 12 years of experience I had settling estates in private practice as a trust and estates lawyer. I've settled hundreds of estates just in private practice nationwide. Was licensed in New York, New Jersey, and Maryland, but happened to be at a large firm where I dealt with estate administrations pretty much all over the country, working with local counsel as sort of boots on the ground where I needed to be admitted. So this will be sort of a 1,000-foot overview, and could be applicable to multiple states, even though it's important to note that at just as each state has its own ethical rules, or I'm sorry, just as each state has its own trusts and estates rules, even though they might use the Uniform Probate Code or the UTC, the Uniform Trust Code, each state also has its own nuances for adopting those rules. The same applies with the model ethical rules in each state. So important to keep in mind that this is going to be a general presentation. Anytime I'm quoting the model rules or talking about ethics, it's very general. So always check your state's specific requirements if you encounter any of the issues that we're going to discuss today. You can learn more about our platform at www.trustate.com. If you're a trust and estates lawyer, definitely check us out. We could probably help you. So again, important to note, each jurisdiction has its own rules of professional conduct. For attorneys, it's important to follow your jurisdiction rules closely. Got to give that disclaimer, being an attorney. So why are we now talking about this? That's sort of my next question. Why is this important to you as a practitioner? Interestingly, particularly when it comes to trusts, estates, and probate, it's because there's a disproportionate amount of legal malpractice claims relating to attorney misconduct in trust, estates, and probates. And yes, that work is a big pain in the neck for many people. It's an area that often leads to errors and, really elongated periods where the statute of limitation doesn't even run for malpractice. So those are some factors to it. But also, if you look at a lot of the malpractice claims in your state, you'll note most of them relate to an ethical conflict of interest that attorney in question had at the outset of the planning. Super common to see. And these issues can be very hard to spot unless you've spent thousands of hours, as I have and my team has, on the administration side. When plans ultimately come to fruition, you're moving assets to those beneficiaries that you've outlined in that beautiful instruction manual that you call a will or trust, and really seeing things come down to where people now are getting stuff and they're either happy about it or not happy, and they're looking for ways to put the attorney at fault. Conflicts, really easy way to put the attorney at fault, specifically when it comes to family representation. So that's why we're here talking about this today. It's really, really important as a trust and estates lawyer to take certain steps to be able to foresee certain ethical issues. And we'll, I guess, dive in from here. So first, I'm going to start with a brief overview of conflicts. What is a conflict? The definition of a conflict is that it arises between an attorney and a client if the interests of the attorney, a different client, or a third party conflict with the interests of the present client. So there's a couple different types of conflicts. There's concurrent/successive conflicts. There's direct conflicts. That's where two clients are directly at odds with each other. That one's pretty easy to spot. Some of the other ones, not so easy. Then there's indirect conflict, clients and third parties. And then there's, lawyer-client duties to third parties. For instance, a duty to beneficiaries, that is under a will. Then there's imputed conflicts. So where an attorney, moves from one firm to another, if that attorney gets conflicted out does their firm in some cases. There's ways to wall that off. We'll talk about that. But that can often be a problem, particularly where, local counsel is moving around and, it's a small town or a small city where there tends to be a lot of interrelation among parties that might be adverse to one another, represented by local firms in the area that attorneys move around to. So, jumping into this in a little more detail, a concurrent conflict is when you represent two clients at the same time, whose interests are directly adverse. So, Rule 1.7 and the DRs deal with this, the disciplinary room rules deal with this. Successive conflicts, again, these are fun to try to find, and really frequently come up in the estate and trust space. That's where you've once represented a client, and now you want to represent someone whose interests are directly adverse. So this is looking at what are your duties to former clients or clients you have that may still be a current client that you haven't spoken with in quite some time. And also, when do you know when someone's a former client or a current client? All good questions to ask. Rule 1.9 and the DRs deal with this. Then there's direct conflicts. Again, these are easier to spot. You can't represent Pepsi and Coke at the same time. That's where your interests are directly adverse to that current conflict, whether that's through someone that you're representing or your own interests, if you're, part of the Coke family, say, so to speak. Indirect conflicts, that's where you have some other interest beyond the duty of loyalty to a client. Actual conflicts, you represent a client in a real estate matter. Another client comes along and wants to sue your client in a landlord-tenant case. That's an actual conflict. Imputed conflicts, again, that's where you have firms, you have to wall off data sometimes if you're moving from firm to firm, and there's conflicts between existing clients or former clients at the firm that you're moving to or leaving, and the client that you're bringing with you there. The larger the firm, the bigger the issue. For those of you listening who work at large firms, you know how annoying that conflicts process takes. It takes, at a small firm, you can get an engagement letter out in a day and start working on a client matter. At a large firm, it could be months in some cases I've seen. So always still important work, but can be a real pain in the neck on the imputed client side. Personal clients, these are conflicts that are personal to you, but not to your work as an attorney. So for instance, you're going to litigate against your spouse. Imputed conflicts, or these conflicts can't be imputed, and these personal conflicts are dealt with in Rule 1.10. Okay, so now we're going to talk about the typical scenario in a trusts and estates practice. So often this is going to arise when you're representing multiple family members and, you're serving in dual roles. Say you're both the attorney that's hired to work on the estate administration, but you're also the trustee or the executor. So you're sort of advising yourself on how to do the work and taking fees for both. So that's one way that you have a conflict. And I want to just mention quickly, and we're going to talk about this quite a bit, the presence of a conflict does not necessarily mean that you can't do the work. The presence of a conflict means that you have to address that work and you have to address that conflict so that you can do the work. There are some cases where a conflict is waivable. There are other cases where a conflict is not waivable. We'll get into that in a moment. So you most certainly, in most states, it's accepted. It may not be best practice in most states, but it's fairly frequent in most places that I've seen where you have many attorneys who are sitting as both the law firm for the administration, whether it be an estate administration or a trust administration, and they're acting as the fiduciary. So it's pretty common thing to see. Again, it's not, pro se, or trying to think of the exact word, prima facie malpractice, will you? Certainly not. But there is some essence of a conflict there that is, again, waivable by that estate's beneficiaries. Those people you have a fiduciary duty to protect, both as the fiduciary of the estate, the executor, the trustee, and then your fiduciary duty to them as to yourself, really, as the attorney for the executor trustee. So there's some, essence there of a conflict that needs to be addressed with those beneficiaries, to say the least. Um, other areas you see it are multiple family members. So if you're representing, this is very, very common. If you've been in the trust and estates world for some time, you work with mom and dad, then you work with their children, you're doing estate plans for everyone. Everything's hunky dory. Everyone gets along. You're not so worried. The work seems very separate, in that you're drafting a separate estate plan for, that young family with a new child, and then you did their parents' estate plan as well, and they own a family business, say. Now one of the parents passes away, and you now have, two quote unquote clients that, may not be in direct conflict with one another, but, there may be some outcomes that say that child doesn't like, but you represented them on the planning side. So you have to be really careful in your engagement letters, which we'll get to really hone the scope of your work as an estate planning attorney. One note on representing spouses, and this, it sounds dramatic, but it actually comes up fairly frequently. So this is when, you have confidences imparted by one joint client. Uh, I've been in many situations where you've had one spouse want to change part of their estate plan or is contemplating an issue with their marriage that they're not sure is workable. And you're representing them jointly doing a joint plan for a married couple. You now have a conflict because this information that one spouse, imparted to you in confidence, that the other spouse does not know, is not aware of, that affects your ability to effectively represent them as a joint couple. You informing the client, the other spouse or the clients as a joint unit of this conflict can lead to issues for the clients. So really important that when you're drafting your engagement letters to joint clients, you're taking this into account and being very clear upfront with clients that if they're going to tell you, hey, I plan to, leave my spouse in 5 years after our kids turn 18, I want to make sure they have less power over my estate plan than maybe I said in the meeting. Really important that you make it abundantly clear at your consultation meeting with them that if they're sharing things like that with you, that's going to create an ethical conflict of interest to you representing them jointly, and that will need to be disclosed, or you might stop representing them, which is going to raise questions and maybe affect their plan, to leave in 5 years and things like that. So all things that are just important to keep in mind. A lot of these issues can get addressed and are quote unquote, if not waivable, addressable. So you don't find yourself in a pickle trying to, figure out how best to navigate a somewhat hairy situation. Because as an estate lawyer, as I say time and time again to so many other trust and estates lawyers, this is messy, very personal work. You're dealing with someone's entire livelihood. When you're drafting an estate plan for someone, it's everything they've worked for their whole lives in many cases, whether it's a probate asset that's going through a will or a trust, or it's just naming a beneficiary on an account. That's personal stuff. And they may have specific beliefs. It comes down to their philosophy on spending and budgeting, their relationships with their closest family members, whether that be their spouse or their children, or those relationships of their family members with each other, even if they're somewhat neutral. So really important to note that, it's an area where there's lots of conflicts. And, definitely never think this work is simple. I always like to say there's no such thing as a simple estate plan. I've literally never seen one. Would love for someone to send me one, and I could probably point out why it's not simple or learn about the situation and tell you why it's more complicated than you think. So, again, just important to note that this work can be riddled with conflicts. A lot of it you can mitigate, though, and protect yourself from and your clients. Okay, so conflicts, why do they arise? Conflicts arise for a bunch of different reasons. It's not always the soap opera I just described to you. Um, Often it's just you have a new client come in and you're looking through your list of prior clients and, say your firm has, multiple practices and say there's a commercial litigation practice on the other side of the farm and you're in trusted estates. And, that client was involved in some consumer class action suit against a company that your client represented. So things come up frequently, or say you're representing business owners, really common in trust and estates, and we can keep it to just purely a trust and estates practice. And one business owner now said, "Oh my God, you're the best lawyer I've ever had. I want you to represent my business partner too." Things are copacetic between them and the business partner now. Is that going to create issues down the line? Again, all things you have to think about when you're drafting your engagement letters for all of these people, really. Divulging facts to an expert so that they can't represent the other side. That's another way a conflict of interest can come up, or a pretty not great technique to use. New matters with an existing client. It may not be that the client's not a new client, but rather it's a new client matter that you're working with them on. Say you're working with, a real estate owner or professional, and they are buying a new strip mall, and you did their estate planning and you work with them on the tax side of these kinds of transactions. But that, you've worked with this client in the past, but it turns out you represented one of the leaseholders within that, one of the tenants that is under the current owner. That could be a conflict. So again, all things that need to be checked out and looked at as you're doing different types of work, or even just doing trust and estates work for people exclusively. New issues in a litigation can cause conflicts. Uh, New parties entering litigation midstream via an impleader or joinder. New attorneys joining your firm. And I gave this example earlier of if you're in a smaller city or a small town or just small region, oftentimes new attorneys carry new baggage in terms of they have their book of business, you have your book of business, and it turns out you have some conflicts within that need to be sorted. Relationships with adversaries, also important. Lawyers becoming a witness to things. You might have done the estate planning and now someone passed away and you're being brought in as the witness to the testator's state of mind. That certainly can come up. Or lawyers having an adverse financial interest, always another interesting one of where, oftentimes, lawyers can, be invested in something and maybe they're working with someone who has an investment partnership, that conflicts with your personal financial interest. So important to just note there. Maybe they want to sue a company you're an investor of or something like that. That's another sort of more straightforward example, but you get the idea. So most commonly, new client is a big reason for new conflicts. So estate lawyers, we often represent families. Conflicts of interest can prohibit representation of multiple family members. This is common in the estate context. And most common example is you represent parents as their longtime counsel, and now the children and the would-be beneficiaries of the parents' estate want you to represent them. These are waivable. So, for instance, if conflicts between competent parties are not substantial and common interests prevail, the lawyer can jointly represent them, or concurrently represent them and act as an intermediary. So really important to keep in mind. So One thing to note is if you're representing a corporate fiduciary, like a trust company, you should discuss potential representation limitations given the other people that you represent in your planning practice or just in your TNA practice generally. Without an agreement, a lawyer representing a corporate fiduciary in an estate administration doesn't represent the fiduciary generally in unrelated matters. So it shouldn't stop you from, if you represent, JP Morgan Chase Trust Company of Delaware. For some reason, you're helping them as local counsel in an area where they're trying to administer an estate. Um, it shouldn't stop you like dead in your tracks, barring anything, any exceptions from representing a party that's maybe suing JP Morgan Chase in, some other unrelated lawsuit on a different side of the bank. That shouldn't cause, an outright conflict that needs to be waived. Those are generally separate and distinct enough from one another, but important to just make note of here. Definitely check your local state's rules if you are starting to work with trust companies and represent them in a certain context or in a limited context, and limit the scope of those engagement agreements, obviously. Some examples of things that are not waivable. Some conflicts are so significant that informed consent is not going to rectify them. You can't just disclose the conflict to them and they can just say, oh, I don't care, and that's fine. These are non-waivable conflicts. Lawyers cannot represent clients with interests that are in severe conflict. Like if you're suing each other, you can't represent, and be on both sides of that lawsuit. Another probably better example in the trust and estates context is prenuptial agreements. I'm sure many of you out here who practice in this field do pre. You can't represent both spouses there. Each spouse needs separate and independent legal counsel. So important to note, you might do their estate planning later on, or say you need to adjust their prenuptial agreement because you're doing something in their estate planning that might mess up one of the obligations they have to one another. So you may need to do a postnuptial agreement. You can't represent both of them in that postnuptial agreement. You need to bring on another attorney. So just important things to just keep note of that will help you down the line and protect you from these issues going awry, which they can and will do. Questions to raise when you're bringing on a new client and you're trying to figure out where conflicts could be potentially. So the first is what capacity are you representing the client in? So here I say capacity. I don't mean state of mind or, whether the client's of sound mind. What I'm referring to here, are you representing them in their individual capacity, like me, with respect to, just my own personal net worth, family issues, etc.? Or are you representing me as CEO of my company? Two very, very different and distinct roles and different quote unquote capacities. Or are you representing me as beneficiary of, my parents' estate, or in my role as a trustee of someone else's trust? You need to keep these in the back of your mind all the time. Obviously, adjust your engagement letters to limit your scope there. Really important, so that if, say, you end up having a really good relationship with that new client that you brought in, they want you to work with them on other matters. Each time, okay, I represented them as a trustee here. Now I'm doing their estate planning. I'm representing them individually. I need a new engagement letter to go out for them with that work. So really limiting the scope. If you have to send multiple engagement letters, that's what you have to do. Those are important things because God forbid you need to wall off some of that. You don't want to necessarily, there may be some that are waivable, some that are not waivable, and you want to keep your options open so you can continue to have a positive relationship with that client over time as your practice grows. The next big factor is connectivity. what connections do the parties have with each other? And I don't just mean with when you're representing joint parties, but rather what connections do, me as CEO of my company have with, my business partners or my family members? How does that interrelate with my estate planning? How does that interrelate with employees or investors? These are all things that are important to look at depending on the capacity that you're representing someone. So in the executive space, or if you're advising a company, you're going to want to look at, those business relationships versus personal and sort of be able to delineate them in your mind. For fiduciaries, you're going to look at the beneficiaries. And are they family members? Are they, kind of more at arm's length? Are these business relationships? Are they personal relationships? Who's a fiduciary? Who's a fiduciary and a beneficiary at the same time? All important things to keep in the back of your mind while you're doing this work, and adjust your engagement letters accordingly. Okay. What's the worst that can happen with conflicts? The consequences of conflicts of interest, um, attorney discipline. You can get sanctions, grievances, be reprimanded, even up to being disbarred for certain types of conflicts. Many of us see this frequently, particularly if we're in litigation, but in no area is it more common than in the trust and estates and sort of like individual private clients space. Disqualification, you can disqualify yourself from the work. That's fairly, straightforward as we think about it. And then Rule 11 sanctions and malpractice liability. If you're having any of these, you're certainly, at risk of being sued for malpractice. So it's important to always kind of keep that one. It's more under the umbrella of malpractice in a way than just a line item here, but just important to be mindful of that this could be a combination of all of these things. So it can be serious. It doesn't feel serious when you're like initially bringing on a new client and everything is wonderful, and the sun's shining and the birds are singing and you're happy to bring them on and they seem wonderful and their family gets along and it's going to be great and they're going to refer everybody to you afterwards. But let me tell you, that can get really hairy, and not be a good situation, as you progress with that client. And even though things may seem wonderful when that client dies in 20 years and you have a lot of concurrent conflicts of interest or successive conflicts of interest, the situation doesn't look as peachy. So just important to be thinking about this stuff ahead of time, foreseeing, and I hate to be doom and gloom here, but all the issues that can come up and protecting yourself, as that attorney, since you are a fiduciary for your client. So now we're going to look at, what the RPCs say for current clients, former clients, and then sort of the law firm versus attorney. So we'll start with current clients. So current clients. So this is all dealt with in Rule 1.7. Except as provided in paragraph B, a lawyer shall not represent a client if the representation involves a concurrent conflict of interest. A concurrent conflict of interest exists if the representation of one client will be directly adverse to another client, or there is significant risk that the representation of one or more clients will be materially limited by the lawyer's responsibilities to another client, former client, or a third person, or by a personal interest of the lawyer. Notwithstanding the existence of that concurrent conflict of interest, here's where it gets waivable. The lawyer may represent the client if the lawyer reasonably believes, that the lawyer will be able to provide competent and diligent representation to each affected client. The representation is not prohibited by law. The representation does not involve the insertion of one claim by one client against another, again, where clients are suing each other, by the lawyer in the same litigation or other proceeding before a tribunal, and each affected client gives, and this is an and, so this is required for a waiver, Each affected client gives informed consent confirmed in writing. Now, what does informed consent mean? That means the client has to be fully disclosed of the conflict, the potential implications of it, and they also need to know that in so doing, they could obtain separate and independent legal counsel to advise them on the actual waiver document. That piece is extremely important. It needs to be black and white and outlined in that waiver document. So just important stuff to note, and we'll get to that, in a little bit. So that's concurrent clients. Now let's look at former clients. And this is always an interesting topic to me because, like, when does representation actually end with respect to trust and estates clients? So, one thing to touch upon is dormant representation, which is going to be the majority of cases. So long as the scope of the representation is narrowly defined, and again, that's being very clear in your engagement letter. I'm representing you to draft your estate plan right now. This is not an ongoing representation that I have with you and an ongoing fiduciary obligation I have to you as your lawyer next year when your estate planning documents have been signed. That representation ended upon the signing of those documents or the funding of those trusts, really outlining it black and white, crystal clear for that client, the start and the end of the representation. And if they want to use you in ongoing and in existing matters, which is the goal, do new engagement letters for those additional pieces or addendums. To that, so long as the scope of representation is narrowly defined, the execution of estate planning documents and the completion of related matters, such as changes in beneficiary designations and the transfer of assets to the trustee of a trust, normally ends the period during which the estate planning lawyer actively represents the estate planning client. At that time, unless the representation is terminated by the lawyer or the client in advance, that representation becomes dormant and awaits activation by the client, i.e., it awaits that client coming out and saying, hey, I need you to revise my estate plan. I had another kid, or I'm getting divorced and I need a new estate plan. Or my financial situation changed, or hey, I just feel like changing things. That's the activation in the future, for that client. So you may wonder, and often I always advise attorneys to hold on to the original physical will and trust documents and store them for the client, because I can tell you how many situations I've seen where the client requests their original documents. They're like, I want to hold on to these. They put them somewhere, whether it be the junk drawer in their kitchen, or their underwear drawer, or God knows where. They write on the documents, which can render them, create probate issues down the line. Really big no-no. But, writing on original wills, they're crossing people out. I think for those of us who watch the TV show Succession, good example of that, where the main character, crosses out his kid's name, but it kind of looks like an underline. That's actually far more common than you think, and why I always advise clients to actually hold on to the original will documents, whether it be a codicil, wills, any testamentary document, including trusts themselves. Give the client an electronic copy with a stamp on it of where it's held. Have a fireproof vault for these purposes, so they come back to you and they formally update things, and make sure and that way you can assure that they've been signed with the right formalities, and are done properly. People like to write on their documents. So anyway, off of that aside, you may wonder if holding on to those testamentary documents actually continues your engagement. And I will say that, the ACTAC has commented on this because it's a valid concern. Although the lawyer remains bound to the client by some obligations, including the duty of confidentiality, the lawyer's responsibilities are diminished by the completion of the active phase of representation. So, even if you're storing it, it's still dormant, I think is where you can sort of safely make an assumption for that. Um, as a service, and I certainly did this when I was in private practice, and the tax laws changed, particularly related to the estate tax exemption going up or down or being gone or coming back, and different trust rules changing and things like that. So as a service, lawyers may want to periodically communicate with that dormant client regarding, the new changes to these laws, which are ever evolving because they're a political hot topic, and the desirability of reviewing those estate planning documents, super common. um that does not mean that you represent that client again. That representation stays dormant. You're also not obligated to send a reminder to that client on these updates. It's nice. And hey, it's a great way to continue that relationship, continue to build trust with that client on sort of as their ongoing counsel on these things. They clearly are going to look to you for this stuff. But it doesn't, it keeps that representation remains dormant until they come back out and say, hey, yeah, I want you to revise my document now. So, sending form letters, pamphlets, brochures regarding changes in the law, are completely fine, and aren't going to bring that representation into an active mode. It will remain dormant. So now let's look at what the RPCs say about joining new firms. So, this is more law firm versus attorney, these imputed conflicts. So, if you're joining a new law firm, how do you navigate this? So, the first step is to identify those potential conflicts of interest. Law firms, especially if they're large, they typically have systems in place to track all their clients and matters handled by each attorney at the firm, and they have a conflicts group that can help identify any potential conflicts. If you're a smaller firm or you're teaming up with another solo, you probably don't have this, but what you do need to do is go through all your client matters together. There's always been this big ethical question that's sat in my mind that I would love the answer to if anyone has, of your duty to keep your client matters confidential and the identity of your clients confidential. Many attorneys and law firms interpret it that way, but there seems to be this free pass when you're doing these conflict of interest checks where you're forced to write the whole list of every client you've ever represented to identify them so you can do a conflicts check. I don't believe there's any hard and fast rule in the model rules or any state rules that I've looked at that shows that as an exception to that confidentiality duty. But it seems to be standard practice that for that limited purpose, you can give them the names of your clients just to check and make sure there's no conflicts there. So, just important to note, you should feel safe in doing that, but make sure that that document, once the conflict check is done, is secured. In a confidential manner and disposed of. If you do find conflicts, whether you're a solo, you're doing this manually, or working with a conflicts group, it's important to promptly inform that client about the situation, the potential impact it could have on them. You want to tell them, here's what could happen, because they represent this person and I represented you. They're relying on you. You're in a position of trust to them, and this is confidential stuff. So, if there's another attorney in there in the firm that was working on something that could be adverse to them, whether material or not, the client needs to know that. They need to understand and be able to foresee how that could affect them in the real world. So you then also, again, that's part of having informed consent, which we'll get to. And then the possible need for them to seek separate and independent counsel now that you're sort of at this new firm dealing with this, or you have this new attorney coming into your practice and you're trying to navigate this piece. Um, Then there's screening procedures. So if a conflict arises due to an attorney moving to a new firm, whether they're bringing in a conflict from a prior client at their old firm, there may be screening procedures that the new firm brings on and implements. That might be walling off data. So it might involve isolating the attorney, making sure they can't see other types of client matters or that other group. Say that the conflict sensing can't see that trust and estates matter. Many firms, particularly large ones, do this as a matter of course. There's very specific protections to even be able to look at trust and estates or private individual clients as opposed to the broader firm. So, that's certainly one way of doing it is just standard default. Nobody in the corporate group or the commercial litigation group can even access any files for, the trust and estates or private client practice group. So those are things just important to keep in mind too. Um, but they might just wall off the data if they don't do that as a matter of course. Informed consent. This is where you're getting that waivable conflict. You're letting the client know, again, the informed part being the key there on so many different levels and seeing what the client decides to do. You also, in a situation where maybe informed consent isn't going to work, the conflict is too great, you may need to decline, continuing to represent that client or withdraw from the matter. So, that does happen too, and is just important to keep in mind. You also need to consider, the ethical rules. Every jurisdiction has their own set of ethical rules. It might be different than the model rules. So always consult, your state's ethical rules that, how your state's adoption of the model code. Again, because we live in the US and every state is its own place and has its own little nuances that are deeply and critically important. Document actions. So this is where you're going to document any actions that have taken place to address this conflict, where the conflict arose, how you see it, what the implications would be, and then the steps you're taking to either waive it or the client's taking to waive it, or whether you're declining, how you're walling off data, all of that. All really, really important to do. Okay, so now we're going to touch on how to actually handle these conflicts. So when dealing with the conflict, first and foremost, and I'm being Captain Obvious here, try to avoid potential conflicts. Um, you know, really just keep in mind when you're working on something or dealing with issues, you're going to want to think about what claims, defenses, issues, and settlement strategies might get raised and what new parties that may impact while you're representing someone. And if a conflict arises, you're going to disclose all potential conflicts to those clients on both sides, and then determine whether they're waivable or not. You're probably going to want to determine whether they're waivable or not first, then make the disclosure. And then again, both the code and the rules permit a client to waive current conflicts if the consent is, again, magic word, informed, and that lawyer makes an independent judgment that the quality of his or her representation won't be affected. So more detail on how to make that independent judgment on my next slide. So determining whether a conflict is waivable and whether you can truly continue to represent them unaffected is complicated. You have to take your emotions out of it, your desire as a business owner. And any of you, whether you're with a private firm, you're your own firm and you're a solo, you at this point are likely thinking of yourself as a business owner. You're trying to build your book of business. You're trying to get new conflicts. You want to bring in revenue, by any means necessary. And you can't always do that. So you have to kind of check that at the side and that kind of self-assess of, oh, this won't affect me. And really think, an ounce of prevention here, worth a pound of cure for later on. So be your own best advocate here and don't let, your desire to grow your book of business, shade your judgment. So here's some steps you should consider. You're going to want to evaluate the nature of that conflict, determine the type of conflict as we've talked about here. You're going to want to assess the severity of the conflict. So you're going to evaluate how severe is this conflict? What are the actual monetary complications that could happen in a whole host of scenarios if I continue to represent both parties? And where you're seeing that, and I would do it really as a dollars and cents exercise. Do the math on it in many cases. Think through your job as an estate planner is you're kind of like a professional fortune teller, and that you're there to foresee all these issues that could come up. Look at them and look at the actual monetary consequences that could occur. Then you're going to want to consult the rules of professional conflict, look at the model rules, look at the commentary there, look at the state's adoption of the model rules, see if there's any state commentary, and look at cases. Really important to do. Then you're going to want to see, well, what's the potential for harm to each client if I represent both conflicting parties? If the harm is significant and it's apparent, it might be that conflict is non-waivable, and that might just be the unfortunate reality of working with people and in being their attorney. But at the end of the day, you can sleep at night and not stress about these things happening, 20 years from now or tomorrow. Next one, waivable conflict. So if you decide that conflict is waivable, here's what's important. And this is common in the intergenerational client conflict situation, which we've kind of been discussing all along. And I'm going to show you how to do it specifically with respect to, these multi-generation estate planning clients that turn into estate administration and trust administration clients. So number one, clearly explain to those new clients, that next generation, those kids, that the nature of the potential conflict due to your representation of that earlier generation, those parents. You want to do that at the outset of the representation. Chances are they're not going to care. They're still going to want to work with you. Your mom and dad's lawyer, they trust you. And, usually mom and dad sometimes will, pay or things like that. So they need to understand, though, that confidential information that's shared in the course of previous relationships might affect your judgment or influence your actions in how you guide them on their estate planning. And though, most of the time you're going to see this as, really a situation where, they're I'm trying to think of an example here is where everybody's responsible. Everybody seems fiscally responsible. But maybe while you were doing the estate planning for the parent who has a small business, you learned that one of their kids didn't like the other kid, or, isn't financially responsible, or had a drug habit when they were a teenager that they've since resolved and now they're an adult. That shapes your view of them. You might want to add a spendthrift trust or some protections in their estate planning documents, or in their children's estate planning documents. That's information, though, you learned from a prior outside representation of the earlier generation. So these are things you just need to disclose in a general way in your, you don't have to get into specifics here because you also don't want to, break confidences about other matters that you have, but disclosing generally that your viewpoint might be a little colored by the fact that you did represent, others that are related to them, I think is key, and it's critical here. Identify potential conflicts. I mean, easier said than done, but start to think about these things. Think about that prior representation. Think about what you've learned there and how it might color your judgment. That's going to help you really think through, as you're representing that new client when you do waive it, how to keep that kind of in check. It's always better to be aware of these things going into a situation than just turning a blind eye to them and thinking, oh, this doesn't apply to me. This is easy and straightforward. Inform them of the right to independent and separate legal counsel. They have a right to consult with another attorney that's not you, and you need to inform them of this, and encourage them to do so about the potential conflict. In many cases, they're going to waive it, but you want it in writing that you inform them, that they have the option and they probably should hire separate and independent legal counsel to assist them on just the evaluation of this conflict. The waiver document itself, obviously, you're going to want to prepare a document and memorialize this in writing. And if they still wish to proceed with you, have them sign, this waiver document. Again, it should very expressly state this information about their right. Basically, if they sign this, you're saying that you consulted with independent legal counsel about this particular waiver specifically, and about, my representation of, these other family members of yours. And then document everything, every conversation you have with them. Memo the file. I can't tell you how many attorneys do not memo the file nearly enough when it comes to estate planning and administration matters. Just memo things. We have so much technology now that'll create AI memos for you. You can just use a dictation device and have a secretary type it up if you're not into technology. But my goodness, memo everything where you can. Mechanics of these waivers. So waivers of conflicts by the client. So you've now sent them this waiver document that hopefully you've artfully drafted. But, something important to note is that, a client who has not, quote unquote, consented may inadvertently waive a conflict. So, delaying for an unreasonable time and an objection to conflict, or can be an objection to the conflict. So important to note there. Them not objecting to it could just be a waiver. Check your state's, model rules that will kind of tell you everything you need to know there. It may vary from state to state. And then no blanket waivers for all possible conflicts that may arise. Of course, you want to draft a bulletproof waiver document that gives you every scenario, because you're, again, that fortune teller. You're seeing all these unforeseen consequences. But that doesn't mean it has to be so general and so broad that the client doesn't even know what they're signing anymore. And there's a pretty good line in the sand on where you sit. Really deal with just the conflict at hand, not like potential conflicts that could come up, and be direct about it to the extent you can without, expressly disclosing information about the prior client to the new client. So important to note. Elements of waivers. So here's what a waiver should have. Full disclosure. The waiver must thoroughly explain the nature and implications of that potential conflict of interest. This should include how the representation might affect the lawyer's duties of loyalty and confidentiality to each client. Potential consequences. Again, talk about the things that you foresee. That's important. They need to know. Disclose that to them. Voluntary consent. Make sure that that client is saying that they're voluntarily consenting to this. There was no consideration for them to consent to this at all. This is totally separate and apart than the business transaction of you representing them, and just something important that they need to do in advance of anything. No consideration there. This is voluntary on their part. Describe the representation. And again, you can get specific there, what matters it's going to cover, and, for what family members. Acknowledge, the acknowledgement of understanding. It should include a statement where that client acknowledges that they've read and understood the waiver, that they're of sound mind, that they understand what they're reading, and they've had a chance, again, to discuss it with separate legal counsel, or, they had the option to seek legal advice and they agree to those terms. They should also have in that document expressly the right to revoke a consent. So what you're going to want to make sure they include is like, hey, if this consent doesn't work for you anymore, you've got to let me know in writing. You want to give them a mechanism to come back and notice you, like, hey, yeah, now I don't waive this conflict of interest anymore because, I'm mad at my parents, or whatever the case might be. You need to give them a way to show you that, because again, you're in that position of trust. That's going to make this document more legally valid later on and more rock solid. Them not doing that. Right to revoke the consent, again, I think is pretty important. It also should highlight documents, whether it be in the attached memorandum to it that's annexed to the actual waiver, or in the waiver itself. It should highlight alternatives to whether it be joint representation or the concurrent representation, just so they know, like, here's your other options. They need to know, like, them waiving something because they're not seeing any other options is also a problem. And then they should sign the document. As attorneys, particularly in the estate world, we love getting signatures on things. Conflicts and how to mitigate them. So, now that we've talked about waivers, let's talk about, when you have stuff, how we can avoid this in the first place. And again, it goes back to those engagement letters. So, one big conflict or one big issue that creates many of these conflicts that exist are vague and seemingly unending duties to clients. As an attorney, your ethical duty to a client, it ends where the attorney-client relationship terminates. That can occur under several circumstances, whether it be completion of the task, which is what you should focus on. That's why I have it highlighted here. Make sure that your engagement letter outlines the task, the scope of the work, and then says when it's complete. So it's very clear where you start and end as their counsel for that particular client matter. The client terminating their relationship, the attorney withdrawing, or the death or incapacity of the client. One thing to note about death and incapacity of the client that I think is particularly important for where we sit in private practice is that duty of confidentiality you have actually extends beyond their death. So it's important to just note that. You might even want to put that in the scope of your agreements and your estate planning engagements, because you can't just go and disclose things after the fact. Those ethical obligations do continue. So now I'm going to walk through a common scenario we see with those attorney as fiduciary situations. That's where the lawyers, the trustee, or the executor. And listen, sometimes it's unavoidable. That or that client has no one else that they can trust, and they don't have any family members, they have no friends, and they need somebody to act as their executor or somebody to act as their trustee. And gosh, can't be their good for nothing child or whomever. So you end up getting appointed, even if you don't want to. So the lawyer is the legal advisor to the client, named as the executor. That will contains complex provisions, including distributing various real estate properties to different beneficiaries, setting up a trust for minor children, and making substantial donations to charity. The client passes away, and the lawyer that's now the executor must carry out that will's provisions. The real estate has now depreciated in value. It's potentially impacting the funding of the children's trust that was in that document. As the executor, you must decide how to handle that situation. So, and you're potentially facing a conflict here, even if you don't realize it. So your options include selling the properties as instructed, risking underfunding the children's trust pursuant to the estate plan, postponing that sale, renting the properties and making that estate administration ongoing, or requesting court modification of the will or trust. Each of those decisions could favor some beneficiaries over others, which potentially lead to disputes. The lawyer, if they represent any beneficiaries in a legal capacity, the conflict of interest could further increase. So multi-generational here could be pretty painful. The lawyer now has to balance their fiduciary duty as executor with their ethical duties as a lawyer working on the estate administration, and they might need to seek outside ethical advice or obtain informed consent from all beneficiaries. Again, this is a pretty waivable conflict we have here, kind of a softball here, but it's saying essentially you're going to want to obtain informed consent from beneficiaries about this conundrum that you're in. And hopefully when you drafted that document, you've given the fiduciary broad flexibility, not only to hire themselves as counsel for the estate. So you want to make sure that that's explicit in the document, that you can use the estate funds as an administrative expense to hire yourself to go and probate the will, because you frankly should hire yourself for this work if you're the scrivener in many cases. You also want to notify, again, that's why the informed consent part is so important, those beneficiaries of this situation that you're in. And what should I do? And then really, what that may come down to is letting them know the potential paths that you take and why you have a conflict here. So, and just important things to note and really be constantly identifying conflicts of interest. Potential ethical dilemmas. Again, that was sort of a good outline of probably several. One, if the attorney as trustee has to make decisions that it could affect them financially, this could lead to a conflict of interest. For example, as a trustee, the attorney could make decisions about how much to charge for their services if they hire themselves, or how trust assets are divested or are invested and divested, distributed, which might affect their own financial interests. Keeping the trust ongoing, if you're the hired fiduciary, you're making a trustee commission every year. That's affecting your personal financial interests. So looking at your job as counsel as separate from your job as fiduciary, which makes more sense? Maybe it doesn't make sense to keep that trust open. Maybe now a beneficiary has a legal argument. Hey, you're hiring yourself and you're sitting there making money off of this being open. And this could have been closed years ago. You're just kind of setting yourself up for conflicts to occur. So things that are just important to just keep in the back of your mind. Undue influence. There's a risk that the attorney might have been seen, particularly as the scrivener, if they were exercising undue influence over the client. So especially if you're heavily involved in setting up that trust or influencing its terms, which often happens when you're the scrivener of the document. Um, Confidentiality. The attorney acting as trustee might face dilemmas related to maintaining attorney-client privilege, especially because those ethical duties don't die with your client. So you might be privy to financial or confidential information about beneficiaries that could affect their management of the trust or your management of the trust, but that information might be considered confidential under the attorney-client privilege rules. Where does that stop? Where does that end? Again, these are just dilemmas that often have to be navigated very particularly when you're the fiduciary in addition to hired counsel. Your fiduciary duty versus your duty to the client. As a trustee, you have a fiduciary duty to act in the best interest of all the beneficiaries. That can sometimes conflict with your duty to your client, the fiduciary, particularly if you're also one of several beneficiaries. So again, these things can just get hairy. Inadequate expertise. Trust administration is complex. It requires specific knowledge of tax laws, investment strategies, and more. A lot of financial advisory type skills in many cases. If the attorney doesn't have expertise in these areas, say they're a great estate planner and an estate litigator, but they don't have a tax background or they're not financially savvy necessarily or to the level that the assets of that trust demand, they may fail to adequately protect the interests of the trust beneficiaries. That could lead to allegations of a breach of fiduciary duty. So again, you run into these issues fairly frequently. Multi-party representation. If you're representing multiple parties involved in the trust, like different beneficiaries, there might be conflicts of interest that arise that lead to ethical dilemmas. Other things to note, individuals have the freedom to appoint any person they prefer in a fiduciary role, which means, yes, you can absolutely act as a trustee, an executor, attorney, in fact. And so many of us do. And frankly, it's a service we do to many of our clients that we don't want to do, but we have to because we're in a position of trust with them. The RPCs, they don't explicitly address the appropriateness of this and of you preparing a document that appoints you as a fiduciary. They certainly address the appropriateness of a document that gives you money as a beneficiary. That's certainly addressed in the RPCs, but not you acting as the fiduciary. Lawyers can assist clients in appointing them as fiduciaries, provided that the client is adequately informed, no conflict of interest is violated, and there is no undue influence or improper solicitation. That appointment could trigger conflicts of interest under 1.7 if it risks limiting the lawyer's independent professional judgment in advising the client on the choice of the fiduciary. So proper client information should include the roles and duties of the fiduciary. Tell the client what the trustee is going to be doing. Put it in writing if they're naming you. Even if it's a separate document, it doesn't necessarily have to be the will, but say what these duties are. Tell them about the role of a trustee or the role of an executor so they can make a better informed decision on whether it's even right for you to serve there. Tell them how lay people can serve with professional assistance. That person that they want to name, their nephew or niece, can hire you as the lawyer to deal with some of the hairy parts. And then give them the comparative costs of appointing a lawyer or a trust company or any significant lawyer-client relationship between the lawyer firm, or any potential corporate fiduciary. So just important things to note. And then lastly, last but not least, since we're coming up on time here, a lawyer's duty of confidentiality continues after the death of the client, as I've said several times throughout this presentation. A lawyer ordinarily should not disclose confidential information following a client's death. However, if consent is given by the client's PR, meaning, the representative of that estate, or the decedent expressly and or impliedly authorize disclosure of that information in order to effectuate that estate plan during the administration, the lawyer who represented the deceased client can provide an interested party, including a litigant. This is common in state of mind issues with will contests, with information regarding a deceased client's dispositive instruments, the will and the trust, and the intent. Disclosure should be very limited in scope. So you can redact and redact and redact, and limited to the information that the lawyer would be required to reveal as a witness. So you're not going to share the entire estate planning memo on how the client hates their kids and this, that, and the other thing if the question is whether the client had capacity to sign their will. You're only going to limit it to, I met with this client on this day, they seemed with it, and that there you go. Big black box, redactions for the rest of the memorandum that you might be brought in to share. Because again, everything else would be subject to attorney-client privilege. So, your duty to preserve the client's confidence, it survives termination of the attorney-client relationship, and it doesn't expire upon the client's death. Disclosure of client confidences could constitute a claim for legal malpractice if the other necessary elements of a legal malpractice claim are established. So just an important note to leave you with, and think about as you work on multi-jurisdictional administration issues, whether it be an estate administration, a trust administration, a probate, or any of your estate and trust planning or closely held business matters where you're advising private clients and families. Thanks so much. And now I'll take any questions.
Thank you for joining us today, Leah.
Yeah, no problem.
The audience questions segment. So if any of you have questions for Leah, please feel free to click that Q&A button at the control panel at the bottom of your screen and submit your questions. We already have a few, so we can go ahead and jump right in.
Excellent. Oh, you want me to just get started?
Yeah, here. I can read the questions out to you. Our first question is, what is the best way to tell clients that there's a conflict, especially in a sensitive situation when close family members are involved?
What is the best way to tell clients that a conflict is involved, especially in a close situation when multiple family members are involved? I think you have to be very clear and documented in writing. So as painful as it is, we do plenty of painful things as, law firm owners and practice group leaders, from terminating employees all the way up through having to tell our clients, some not great news. So I think the first thing you do is it depends on the conflict. If it's a new client matter that's coming in that creates conflicts with existing ones, you talk to the existing client first if you have ongoing representation with them. If it's the opposite situation where it's a former client and there's a new client coming in, you're going to talk to that new client first. So I would do it almost in a vacuum. You don't want to send out with a family-wide notice to everyone involved at first, but rather see what sort of, the person who's creating the conflict in a way, whether inadvertently or not, address it with them first and be direct. I would have a conversation and follow up with notification and a notice in writing, and go from there.
Awesome. Thank you for that insight. Our next question is, have you found that clients usually find new representation if there's a waivable conflict, or do they proceed anyway?
They proceed anyway, particularly in the estate planning and administration and trust administration context.
And then our last question, very similar to that, but are there any good strategies to avoid losing clients and businesses due to conflicts?
Any strategies to avoid losing clients and business? It's really to just be straightforward. There are things you can do. Sometimes it's going to result in a short-term loss, but a long-term gain. So I think it's just one of the things that comes with practicing. As far as how it affects your business, in my opinion, you might lose business in the long term, but you maintain your your reputation as someone with integrity, that people respect, in the long term.
Awesome. Well, thank you so much. I think that's all the questions we have time for today, but really informative presentation. And we're so grateful that you were here for questions as well. So thank you so much.
Great. Thank you.
Awesome. I'm going to go ahead and hand things back over to my colleague, Marina. She'll do a few housekeeping matters and wrap things up.
Yeah, thanks, Leah, and thanks, Nina, and thanks to all of you for being here today. We hope you enjoyed this presentation. I did see some engagement coming in, so I think you guys learned a lot. Something else I wanted to throw out there for you guys before we call it today is that I assume some of you here are estate planning attorneys, and we have something new and exciting for our Justia Elevate clients. And that is for those of you that might have a Justia Elevate website, we've now launched the Justia AI Writer tool. And this tool can help you go ahead and easily generate content for your practice area pages on your website in a few quick clicks. One of the practice areas that is available for your website content generation through our AI tool is estate planning. And so if that's something you're interested in, we encourage you to check that out. If you don't have a Justia Elevate website, or you're interested in Justia Elevate websites, or you just want to know more about our tool, please, by all means, check out our marketing site at marketing.justia.com, or just give us a call. Our team would be happy to explain that for you as well. Have a great rest of your Friday and have a fantastic weekend.
Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please click the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next video.